Mr. Williams, you're owed an apology. I haven't been addressing you by your title. You are indeed Mr. Commissioner, so please take my apology. And with it, my injunction that concision is greatly to be prized over verbosity, and therefore I encourage you to bring your very eloquent submissions to a speedy end.
I intend to. I'd wanted also to direct your Lordship's attention to the DPP of Fiji and AG Fiji case. That's where I broke off. Both for the person point and also for the point of how public officers can use their private capacity in furtherance of their public office. And with the actual application to Indica. So the DPP of Fiji, AG Fiji, is, I'm going to go to page 1214 of the electronic bundle, which I guess might be 1215. It is page 683 of the board's judgment. This is a case 1982. You know what you might remember before the break I said it was the question about whether, this is Lord Fraser of Tully Belton's judgment, and we are at 683F. And if any, the constitutional provision under which the action was brought is there outlined or extracted at F. Note it says in the first line, if any person alleges that any provision of the Constitution, so the key thing there was person. And Lord Fraser goes on to say that the subsection shows that private individuals were who the Constitution seems to have had in mind, but does it also apply to the DPP, therefore a public office or a public authority? And at the following page, the Lord Fraser for the board says, there is no difficulty in construing the word person in section 97.1 as including the holder of an office. And we say the word person in section 136 must include the holder of an office. And it goes on to say, which we buttress what I said before the break about the definition of person in statutes. And indeed, we have quoted from Bennion, where Bennion says, when it means a natural person, statutes will say the individual, as opposed to the person. But then the question then was raised, could the DPP have brought this action? And at page 684F, they make the point that he could have brought the action certainly, either in his own name, AB, being the Director of Public Prosecutions, or in the name of the Director of Public Prosecutions. So whereas I say similarly, prosecutions could be brought on Indica's behalf by the Commissioner. And since 26.1 says that any officer of the Commission may act for the Commission, it could also be brought by one of these officers, saying that, and state that it is by using his official office, by saying, as Mr. Lewin said in this case, Dave Lewin, investigator of Indica, making it clear that it was being brought in furtherance of his public office. The other point, to make this point further, could be seen at volume 8 of the Bundle of Authorities. This is an extract from Halsbury's, page 3661. 3661. I suspect it might be R2.
Yes, probably.
Yes, this is the principle of legality, which is, and this is Halsbury's volume on constitutional law. So it's the principle of legality.
Which tab, please?
Oh, it's tab 137.
Thank you.
My 3662 only has notes on it.
So, as far as that? It could also be 3666, I understand. But
yes, I got it. Paragraph 7.
Right, the principle of legality.
Yeah.
I think what has happened, I think it is repeated in the next tab, which is a different edition of the, in an earlier tab, which is a different edition of Holsbury. I think that's the problem why it might be shown twice.
Well,
Yes, so using the modern one, at paragraph 70 of the subparagraph 2, and if your lordship see it, which begins as far as the capacities that go with legal personality. Yes?
Yes.
Yes. The second sentence, individuals who are public office holders have the capacities that go with the legal personality that they have as natural persons. So the Commissioner of Indicom, the Investigator of Indicom, have in their public office the capacity that goes with their personality as natural persons. Malone is relied on for this, but I would respectfully submit that Fiji could also have been relied on, DPP of Fiji, could also have been relied on for that proposition. Yes. Whilst I'm on that page, I would just note that the subparagraph 1 above also makes the point that mistakes of law are not a defense. If your lordship see the second sentence in subparagraph 1, the existence or non-existence of a power or duty is a matter of law and not of fact, and so on. So since I'm on the page, I just said, let me mention that as well. Displace my notes. Here they are. Thank you. So the other point that I would want to make is, throughout this appeal and this matter, we are confronted by the full code argument, in that, is the Indicom Act a full code of the powers and functions, etc., of the authority? And the argument made at the Court of Appeal, and I suspect made by my learned friends, is it is the full code, and that there are no powers that Indicom has outside of those enumerated in the statute. That I suspect would be the argument. I would respond by saying, no, the full code argument is one which has, which as regards the power to prosecute, has failed previously before the Supreme Court in Rollins. And Rollins will be dealt with more fulsomely by my learned friend, Queen's Counsel. But if paragraph 25 of Rollins, and Rollins is at volume 3, tab 50, page 1856, that full code argument is rejected and says, and the power to prosecute for particular offenses was found out with the Act. And indeed, there are numerous examples where the power to prosecute is not in the Act. The case of Hunt, which my learned friend also deal with, is also an authority on that point. So, what then? Where do we begin to look for the functions of Indicom and so on? In the Indicom Act, the Interpretation Act says functions includes powers and duties. The interpretation section of the Indicom Act. Functions includes powers and duties. So we have to ask ourselves then, what are the duties of Indicom? And I would turn to your Lordship's judgment in Jamaicans for Justice and Police Service Commission, which is at tab 42 of volume 3 and page 1690. I mean, some of your lordships sat on that case, and I would just take your lordships very quickly to the paragraph 21. Your lordships extracted the Constitution of Jamaica, and whereas the state has an obligation to promote universal respect for observance of human rights. That's at paragraph 21. Turning the page, no organ of the state shall take any action which abrogates, abridges, or infringes these rights. Paragraph 22, your lordships rely approvingly on the Caribbean Court of Justice decision, where it says that that section of the Constitution, beginning with whereas, is intended to have the force of law. And then in discussing the resolution resolving the matter, at paragraph 28, your Lordship opined that at the Court of Appeal, the case got bogged down in a technical dispute about whether there was an express statutory duty to make further inquiries. Clearly there was not. But that does not answer the question whether the proper discharge of the statutory functions, which the PSC did, have required it to do so. Clearly it did. So what your Lordship was saying, if I understand it, is the first role of public authorities in Jamaica must be promoting, securing, and safeguarding fundamental rights in the Constitution. And when it comes to fundamental rights breached, allegedly by members of the security forces, which fall to INDECOM to investigate, that is INDECOM's special interest. It is what INDECOM is peculiarly advantaged to prosecute. Because if one goes before a justice of the peace to secure a summons or a warrant, the JP will ask questions about the case. And who better than the investigator to answer those questions? If INDECOM were, on the other hand, to have there would be a murder which didn't occur, was not committed allegedly by police or soldiers, that would be out with our statutory remit. And even if we had done some investigation preliminarily of that by mistake or by misinformation, that certainly would not fall within our remit for prosecution, because that would not be within our special interest. So I say that to say then, the full code argument has to appreciate the constitutional requirement and the procedural obligation with which I started this morning. That is my submission on that point. My learned friends on the other side have raised issues surrounding Section 28 of the INDECOM Act, which I will take you to right now. INDECOM Act is in tab 8 of volume 1. This is a new submission, of course, being made for the first time at this level. And the submission, as I understand it, is that Section 20...
Well, you will have a right of reply, Mr. Commissioner.
Oh,
you will have a right of reply. But if you feel that you must anticipate the argument, by all means do so. But I'm slightly troubled by your introduction, your prefatory words, as you understand the argument. It might be better to be clear as to what the argument is before you attempt riposte to it. But it's a matter for you.
I'll take your guidance, Lord, and indeed we have also made very fulsome written submissions.
Yes, indeed.
Reply. The case that I would like to take you to next is the Stedroy Benjamin case, which decision of the board regarding the role of the DPP and prosecutions. In that case, referable to the police. Tab 30, I'm sorry.
Which bundle, please?
Oh, I'm sorry. Volume 2 is 1248 of the electronic bundle.
Tab 30.
It's tab 30. The case concerned whether the DPP had a power to prevent a prosecution. Could the DPP tell someone, do not prosecute that case? Because in this case, the DPP had indicated to the police not to prosecute Mr. Benjamin. And the police went on and did that. And in this case, the Lord Wilson, in the unanimous opinion, has set out the important principles which I would like to rely. The first is at paragraph 16, and that is, at common law, every citizen has the power to prosecute. I may pause, my lord, because I may not have time to take you to it. And it is this fact. In the judgments, particularly of Madam Justice Phillips and Mr. Justice Brooks, it repeatedly says the power to prosecute has been impliedly taken away by the Indicum Act. And we set out all the sections where they say that. Impliedly taken away by the Indicum Act. But common law rights, such as the power to prosecute, cannot be impliedly taken away. And we rely on the Whitham case, and more so the Unison case, which makes that point repeatedly. You cannot impliedly take away common law rights. It must be express words that take them away. And indeed, Justice Phillips, in her judgment, said that there were no express words. And what has been relied on is repeated reference to investigations mean that you cannot prosecute. At paragraph 23, in the Steadroy Benjamin case, Lord Wilson makes 3 points. One is that the Director of the Public Prosecution has no command over the police force. Similarly, DPP has no command over Indicum. The DPP can initiate a prosecution, but if he exercises this power, he does so in his own name. Because a point is being made that, well, can the DPP do all these prosecutions? But in Jamaica, the DPP does not initiate prosecutions in her own name for there to be preliminary inquiries or other proceedings in the summary court. Because all cases start in the summary court, and they begin with an information laid by the police or some other prosecutor. And it would mean the prosecutor laying that information has to be convinced that it's a sufficient case to put before the court. So what it would mean then, if the Court of Appeal is correct, it would mean that the police would have a right of veto over the prosecuting of cases following an independent investigation by Indicum, because the police are not compelled to follow the directions of the DPP. So it would mean investigation by Indicum, the Court of Appeal would say DPP consenting, and then it would mean police consenting, and that would not be independent. It would also mean, I give an example in the Michael Gale case. If Mr. Gale had survived, it would mean that we would have had what is called in Jamaica a case and cross case. That is, the police saying Mr. Gale attacked them, Mr. Gale saying police beat me up without any good cause. It would mean that in Jamaica we'd operate an unequal justice system. That is, for Mr. Gale's case to charge the police, it has to go to the DPP for permission to charge, whilst the case against the citizen would go to the court without any such impediment and immediately. So we'd be waiting for the DPP to rule, whilst the case against him would be ushered into court without any impediment. That is not the justice system that we ought to operate in Jamaica. At subparagraph 3 of 23, Lord Wilson recognizes that in Antigua as in Jamaica, those provisions of the Antigua Constitution, which are similar to 94 of Jamaica's, expressly recognize that criminal proceedings can be instituted by a person or authority other than the DPP. So that's the common law, nor power. And that subparagraph 5, that the DPP has no other power to control any other person's or authority's power to institute prosecutions. Yes. I would turn to paragraph 28. Sometimes a statute, for example, and the Lordship use 4.1 of the Biological Weapons Act, provides that criminal proceedings can be instituted except with the director's consent. That's a typical thing done in statutes. And in our case, we noted that there are a number of statutes in Jamaica. We think about a dozen that we could find, where there's an express provision requiring the DPP to consent. And in the case, we set out the history, which I just mentioned briefly. In the PPCA Act, which the Indicom Act repealed, there was a provision that where the police were going to charge one of their members, they should seek the DPP's approval before charging. That was repealed when the PPCA Act was repealed, and no such provision was put in the Indicom Act. So why do we read the Indicom Act with that provision in it? And further, we make the point in the case that at the time of the passage of the Indicom Act, there were other, Indicom is an ombuds organization. There were a number of other ombuds organizations in Jamaica. Children's Advocate, the Contractor General, which did public contracts, the Public Defender, and they had explicit provisions preventing them from bringing criminal proceedings. No such provision in the Indicom Act, which followed them historically, so they were already in existence. And so from the same template with a lot of similar provisions in the Child Care and Protection Act for Children's Advocate, Contractor General Act, a lot of the same provisions are repeated, but they did not repeat the provision preventing them from prosecuting. I read on in Stedroy Benjamin, paragraph 29. Paragraph 29, Lord Denning in Ex parte Blackburn is approved to make the point that the Commissioner of Police had a duty to cause cases to be prosecuted that were fit to be prosecuted. And I would say that given the constitutional procedural obligation of the right to life, that responsibility now falls to the Commissioner of Indicom within Indicom's limited remit of alleged offences abusing citizens by the police. The last point I would make from Stedroy Benjamin is that at paragraph 31, the DPP of Antigua and Barbuda made the point that the DPP was solely responsible for taking all prosecutorial decisions. And the board said, next paragraph, that that was incorrect. We have a democratic system of initiating prosecutions. The other point I would make as regards this point is, at the Court of Appeal, the DPP agreed with these submissions. The submissions that we are making as regards Indicom's power to prosecute and not needing the DPP agreed with them at the Court of Appeal, as did the AG. The other one is a practical issue, my lords, that it's an important procedural right to be the initiator of a prosecution. You have the right to choose counsel. You have the right to withdraw the case. You have the right to appeal. And indeed, in this case, if Dave Lewin had not been the prosecutor, this appeal could not have been brought to the Privy Council. Because, and interestingly, you will note that the Dave Lewin matter raises a lot of issues regarding how Indicom operates. And if it had not been but for the fact that Dave Lewin was the prosecutor, we would have had to have depended on the police to bring this appeal, or the DPP. And the DPP at the Court of Appeal expressly said that they were not interested in taking the matter any further. There is another issue that one must make as regards this point. Jamaica is, as I've said, 2.5 million people. But Jamaica's criminal jurisdiction is divided into 13 parts for the 13 parishes of Jamaica. So there are some parishes which have very small prosecuting offices for the clerk of the courts. 1 or 2 in some parishes. So one could have a situation where the clerk of the courts prosecuting the case in a cross-case situation would be the same one who prosecuted the other part of the case. A most unhealthy, and it's not one which encourages public.
Confidence.
I'm obliged, my lord. Okay, but I believe more will be said by my learned friend on that point. Your lordships will note that we have said that the right to prosecute is one of ancient vintage, and I have been at pains on this side to put before your lordships the Royal Proclamation of 1661, which brought, after Jamaica was conquered by the British, Jamaica used to be Spanish, the Royal Proclamation brought all the rights of Englishmen to Jamaica in 1661. So it has been a long period for the common law rights to be part of the law of Jamaica, this common law right to bring a prosecution. And in that regard, I would take you to Halsbury's, volume 8. Okay, with judges. Okay, with judges. Yes, it's tab 140 in volume 8. 3672. 76? It could be 3676 of electronic bundle.
What's the point that you're trying to make here?
The point I'm making there is that when dealing at paragraph 23 with the general power to prosecute, at the third paragraph, the point was made that various other public authorities, including several government departments and non-governmental statutory bodies, may initiate or conduct criminal prosecutions.
Well, I think that point has been made already, hasn't it?
It has been. At the note at paragraph 8, footnote 8, is noting that it is the very same private right being employed. And indeed, in the Stedroy Benjamin case, the point was made when contrasting the police power to prosecute, that indeed all public authorities have this very right.
Footnote 8 suggests it's a common law power available to public authorities.
That is so.
Yes.
I think I have said what I had wanted to say, unless there is anything else that your lordship would particularly want me to address.
Well, in a nutshell, your case is that, Commissioner, you have as a public official a common law power to prosecute. There is nothing in the Act which takes it away. Case, isn't it?
Yes, and indeed, and it would not just be the commissioner. It would be
the officials with the authority of the commission.
Indeed. In fact, I didn't point you to Section 9 of the Justice of the Peace Jurisdiction Act, which I think I should point you to. It's quite important. So I can find. That would be Volume 1, I would think, because it's a statute.
This is the Justices of the Peace Jurisdiction.
Jurisdiction Act, yes. Just to make the point that it's tab 12. (988) of the electronic bundle, I believe, my lords.
What page?
988.
Thank you.
Right. And in fact, I'm going to Section 9. On to Section 9, which is at page 996 to 997. This is an old act, so it's written in a very old style, with very long paragraphs, but it begins by saying, fifth line, that the information may be laid with oath, without any oath or affirmation. except where arrest warrant is required. But I want to take you to the end of paragraph 9, of section 9, 4 lines up. And every such complaint or information may be laid or made by the complainant or informant in person, or by his counsel or solicitor, or other person authorized in that behalf. So the information could be laid on behalf of. And when you combine that with section 26, which says the Commission acts through its, I'm paraphrasing, acts through the Commissioner and its staff. We say that when Mr. Dave Lewin laid that information, he was acting in furtherance of his public office. Indeed, on this point, we agree with the judgment of Justice of Appeal Frank Williams, who at the Court of Appeal agreed that charging was an important function of the public office of the Commission, disagreeing with Madam Justice of Appeal Phillips. And my lords, the time I've saved, I know it's in the Senate, in America, they always say, can I cede my time or get back my time? So the time that I have ceded this afternoon, I hope I'll get back if I need to in response.
I'm afraid it doesn't work that way. Thank you very much for your very concise summary. Thank you. Mr. Fitzgerald.
My Lords, on behalf of I've prepared a very short note summary of the submissions in order to enable us to gallop through it with a suitable pace. My Lords,
Well, a brisk canter rather than a gallop. A brisk canter.
A brisk canter, yes. Well, my Lord, it's a bit like Hamlet without the prince. I'm representing Indicom, but the commissioner who I'm representing is standing there. So, this is...
It's a bit like Hamlet with an extra prince.
Paper without the memory stick.
Oh, thank you. Shall I provide...
No, I can cope with paper, but if you've got it on memory...
Oh, yes, we can. Yes, that wouldn't be a problem.
Okay.
Yes. So, really, my Lords, the basic proposition is that both the Commissioner, the Commission, acting through the Commissioner, and any officer of the Commission can arrest, charge and prosecute a police officer whom their investigations have revealed to have committed a criminal offence. And that point is spelled out in more detail in the case at paragraphs 88 to 89. Unless you wish me to, I won't take the court to that, but the exact way that we put the various powers that are possessed by the Commissioner and the investigative staff are set out at page 712 of the case. And we further submit that the Commission can do so without the permission of the DPP. The Constitution, and we've given you the reference there, makes it clear that the DPP has the power to take over and discontinue, but no exclusive power to initiate prosecutions. And as my learned friend has shown, the case of Stedroyd Benjamin makes that absolutely clear. I think it's paragraph 33. But, so the facts giving rise to these proceedings, very, very briefly, they're set out in the SFI. In the case originally brought against Corporal Reid, an investigator of Indicom, that's to say Isaiah Sims, obtained an arrest warrant and charged Corporal Reid for murder without the consent of the DPP. It would appear that the lack of prior approval by the DPP was the reason why a nolle prosequi was then issued by the DPP. But it's our contention that no such approval was needed and that the Indicom officer was acting within his rights. We know that fresh proceedings were then issued, but tellingly, the new prosecution is still awaiting trial 9 years after the DPP intervened. I understand a trial is fixed for October of this year now. So that we say it would have obviously proceeded much quicker if it had been conducted by Indicom. But one sees our submissions are, Isaiah Sims, the Indicom investigator, did have the right as a private citizen to charge Corporal Reed. That was recognised by 2 of the Court of Appeal judges, and we've given you the summary in the SFI. But more to the point, the central point is that the Indicom investigator also had the power to prosecute in the exercise of the general common law power conferred on an officer of a statutory authority to prosecute in the exercise of his overall public function. My Lord Hodge summarised the point to my learned friend, and that is the central point that we respectfully make. And we rely here
Forgive
on
me,
the
Mr.
authority of
Fitzgerald.
Hunt.
Forgive me, Mr. Fitzgerald. Is that done in a personal capacity or in his capacity as an officer of Indicom?
In capacity as an officer, we would say.
Thanks.
So the personal capacity is Roman 1, but we rely on, it should be Hunt at core volume 2 of the authorities bundle. I will be going to it, my Lord, but can I just summarise the position? Is what was said there is that the Inland Revenue Commissioners have the common law right of public officers to commence a prosecution in support of their functions or their duties, the duty being to collect taxes, and so they have the common law right to prosecute. I will take you to the details of the Hunt case, and in the Rollins case, which dealt with the Financial Services Authority, similar statements were made at paragraph 14 and paragraph 17 to 19, and that's because they are peculiarly advantaged as the authorities that can carry out the prosecution. More generally, we submit, Indicom itself, as a statutory authority, had the general power to prosecute in order to fulfil its statutory function to investigate, expose, and deal with police misconduct that it is discovered as a result of its investigations pursuant to a complaint. And in that respect, we rely on the reasoning of the full court, which we summarised below. So we place key emphasis on the right of the Commissioner and his staff or officers to prosecute in exercise of their overall functions. And we submit that the functions conferred by the Indicom Act include the functions both to investigate the alleged misconduct of the police pursuant to a complaint and, where necessary, the power to initiate the arrest and charge of police officers against whom complaints are made to Indicom. That's echoing the language of Justice Marsh, sorry, it should be Marsh, in his judgment of the full court. To like effect were the findings of Justice Campbell and Justice Fraser, and I will take you very briefly to the key paragraphs. So if we, the main propositions and factors that we urge before your Lordship's board are firstly that the history that led to the legislation and the fact that it was designed to ensure respect for the right to life after the Inter-American Commission had found there were defects in the investigation and prosecution of the police killings of Jamaican citizens. That's the background. And given that, we submit that it is part of the overall function of Indicom, read in the light of the state's obligations under the Constitution and international law, to ensure respect for the right to life by both an effective investigation and, where appropriate, a prosecution of the police. We rely on the reasoning of the full court as to the absurdity of establishing an independent body to investigate allegations against members of the police force, but then to leave it to the police and the DPP alone to initiate the arrest and charge of such officers. We rely on the provisions in the statute itself providing for the independence and separate initiative of Indicom as a safeguard against police abuse. Fourthly, we say that the statutory language relied on by both the Court of Appeal and the first respondent to oust or restrict the power and duty of Indicom to arrest and prosecute is manifestly insufficient to do so. Fifthly, we rely on the case law, including the decisions in Hunt, Rollins and Securiplan, which all recognise the right of a public authority and its officers to initiate a prosecution to ensure the proper discharge of its overall functions. And I stress overall because it's not, we say, limited just to investigation. Then the fact that the Constitution itself, in section 94, expressly recognises and enshrines the common law right of a person or authority to initiate a prosecution without the consent of the DPP. In other words, I think I can take some of the first part of what follows very briefly, because my learned friend has dealt with it very fully. In the case in the Diah case, it summarised the legislation by my learned friend, Mr. Williams, at paragraphs 5 to 12 and 67 to 84. And he's taken you this morning to the Inter-American Commission's decisions. And the simple point we make, echoing him, is that the defects that were identified, and my learned friend took you to paragraphs 93 and 94 of the Commission's decision, and to paragraphs 98 and 99, were the failures to properly investigate and properly prosecute. And if one looks at the end to paragraphs 104 and 105, and then to 114 subparagraph 2, where they're dealing with their recommendations, it's clear that they're saying you must introduce legislation which provides both for proper investigation and proper prosecution of the abuse of powers by the police that led to the death of a citizen. And it's paragraphs 93 to 94, there is clear reference to the lack of prosecution. So therefore, for the reasons given by the appellant in the Diah case and by the full court, we say that both the history of the legislation and the need to ensure conformity with the human rights obligations of Jamaica support a broad and purposive approach to the determination of the question of what the functions of Indicom are under the Act.
Question might arise, why is a purposive approach to interpretation required at all? I mean, why not make it explicitly clear that Indicom and the Commissioner could undertake prosecution?
Well, my Lord, what the authorities say is it's not normal to spell out a power of prosecution because it is implicit. And my Lord, that's said in, for example, in the Secure Plan case, that it's just not the normal way.
Yes, but this wasn't a normal situation that we were confronting. This was the creation of an independent body to carry out investigations which stood apart from the conventional authorities that are charged, the conventional state authorities that are charged with the investigation of crime. So if you're going to invest that body with myriad powers, why not depart from the norm and say, incidentally, it has powers to initiate prosecution?
Well, my Lord, I accept that they don't do that, but I say that if one looks at section 20, the power to arrest, and if one looks at section 34, which preserves the existing rights, they serve that function. And my Lord, one of the key points is the argument from absurdity, which the Court of Appeal, which after all, the full court identified. It's
not just the silence that troubles me a little. If you read the Act as a whole, you get the impression that the functions of Indicom are firstly to conduct an investigation for which they're given some quite large powers, vast powers, I think the court below described. Then to write a report, to make recommendations, which might, one thinks, include a recommendation that somebody be prosecuted, and if those recommendations weren't accepted, then to lay effectively a complaint about the non-acceptance of their recommendations before Parliament. Now, it seems, at any rate to me, slightly strange that those latter functions, namely to make recommendations and then to complain to Parliament if they're not followed, are there and nothing is said about prosecution, because in the ordinary course if they had been the body intended to conduct the subsequent prosecution, one might have thought that the structure of their functions going, what they do after they've completed their investigation would be differently expressed.
Well, my Lord, can I try and address that?
Yes, please.
The recommendations may relate to a whole series of things. They may relate to how the firearms are kept, how they're distributed, how they're used. They may say issue a new protocol for that, a recommendation of a general nature, rather like the coroner's recommendations where a death occurs, makes a recommendation to avoid further fatalities. And if nothing's done about that, so no new protocol is introduced, then one says, well, you can go to Parliament and say, but my Lord, it is of course our case that the power of prosecution is there all along, because this is a public authority with the inherent common law right to prosecute, and that would have to expressly be taken away, whereas Section 34 suggests that it's still there. I accept, my Lord, that there's Section 34 is how we put the case. We say Section 20, subsection 1 is also consistent with that. But, my Lords, that's how I can take you through each of the provisions which the Court of Appeal relied on and indicate why we don't accept that they point to the absence of a power to prosecute. I mean, the powers of recommendation, there's a whole series of powers which I've dealt with very shortly at Part 5, but the sending a copy to the DPP of the complaint is consistent with a concurrent jurisdiction that my Lord has indicated. The consultation before the case is dealt with by mediation again, one can see why one would want to have consultation of the DPP without the DPP having the exclusive right to prosecute. The furnishing of a copy of the investigation report under 1710D, well, a whole series of people are furnished with a copy of the report. I mean, I think there's about 8 different authorities. So it's not exclusively saying that the DPP must have a copy of the report, but a series of authorities. And the power, that the recommendations must be complied with, Section 23, and if they're not complied with, further steps, we say is not pointing to anything about prosecution or how the prosecution power should be exercised, but covers the wide nature of the recommendations that may be made, and they may be of a general nature to prevent future fatalities by the adoption of a new policy, a new protocol, a new approach.
It results to this, whether it is incongruous that in setting out the panoply of powers that are given to Indicom, it's incongruous that they didn't follow through and refer to the power to prosecute, or alternatively, whether that would be unnecessary given the traditional approach that a public authority and an individual does apply to prosecute. It was unnecessary to explicitly state that in the legislation.
My Lord, that's really the difference between my own friend and myself. But, my Lord...
That's the nub. That is the nub.
That is the nub of it. Nonetheless, could I just show you one paragraph in each of the full court judgments? Because
by all means, besides the nub,
just to drive the point home, my Lord, what we say is that the full court rightly identified that it would be very curious to set up a new body which is going to be uniquely advantaged in knowing what went on. May well, for example, there may be someone who goes to Indicom because they're frightened for their life and tells them the full story. And then you have to tell the full story and hand over the prosecution to another body. I know it's said, well, it can be handed over to the DPP, but we know that the DPP very often then hands it back to the local court clerk, who's probably very close to the local police. And it would be strange to create the body that has this special knowledge and this special investigative function, and then to deprive it of the power to do anything about it by way of prosecution, without expressly saying that that power, which is a normal incident of a public official engaged in that particular domain, has been taken away. And, my Lord, it may be that the question is how widely one interprets the notion of the functions in the discharge of which the public official is. We say it's not just to investigate, but to investigate and take the necessary steps consequent on that. My Lord, that is really the heart of the full court judgments. And if I could just give you those references. In the judgment of Justice Marsh, it's electronic bundle page 91. It's certainly in my version. It's got 84 at the top. Paragraph 87, where he says, after citing a Hunt, and where you can see the citation from Hunt at 86, great importance has always been attached to the ability of an ordinary member of the public to prosecute in respect of breach of the criminal law. If an ordinary member of the public can bring proceedings for breach of the criminal law, it would be surprising if the Inland Revenue were not in a similar position. So that's the peculiar. Why should the peculiarly advantaged body charged with supervision of this particular domain, in this case police killing or police misconduct of a serious nature, be deprived of the very power which the ordinary member of the public has? And what one sees in the judgment of Justice Marsh's, it would, to my mind, be an aberration for Parliament to have established an independent body removed from the police force to investigate allegations against members of the police force, among others, by citizens of Jamaica, but still have the first defendant and his investigators having to rely on the police or the DPP to initiate arrest and charge police officers against whom allegations are made by citizens. This would certainly be a classic case of an absurd state of affairs that Parliament cannot have intended. And there's a citation from Rollins, which is the FSA case, as your lordships will know. Justice Campbell, again, it's just one paragraph, my lord, 156 to, well, sorry, 3 paragraphs, 156 to 158, but and that's an electronic bundle, page 121, after the citation from the case of Rollins, Gurrier and Broadmoor, and one sees the citation from Broadmoor at 156, if a public body is given responsibility for performing public functions in a particular area of activity. So that's quite a broad description. In a particular area of activity, we say functions in respect of the supervision and bringing to light of police misconduct or police killing, be implicit that is entitled to bring proceedings seeking the assistance of the court in protecting its special interests. That was an injunction, but we say the same principle applies to the common law right to prosecute. The Commission has always had the right to bring prosecution subject to statutory restrictions. The fact that it is not expressly stated in the Act is not an irregularity. The Act gives the Commission the responsibility of performing certain public functions as it pertains to the investigation of complaints and incidents concern the members of the security service. These responsibilities were assigned the Commission against the background where the previous legislative framework had led to complaints of continued human rights abuses. In Rollins, Sir John Dyson notes that the technique usually employed by the legislature to indicate an intention to limit the class of persons who may prosecute is the obvious one of stating expressly that a particular offence may only be prosecuted by a specified person. So, my lord, that's the obverse of why didn't they do it? Why did they not rule it out, given the fundamental common law principle that a public official can prosecute? And then there are many rational reasons for Parliament not restricting the Commission's right to prosecute offences their investigations lay bare, paramount among which is that the Commission has been given greater control over the investigatory process. I mean, why are they given this control over the scene of the crime and obviously the power, because in Section 21, to conduct an identification parade, and then they have to say, well, terribly sorry, we can't take it any further. And to the informer or person who comes to them and says, I'll speak to you, but I'm not going to speak to the police, that person has to be handed over to another authority and without the same necessary protection. I find that the practice such as existed between the DPP and persons against whom allegations were made insufficient to disturb the right of the Commission to prosecute. And again, Justice Fraser is at paragraph 315. It's a massive judgment, but 315, page 176. Having carefully considered all the submissions and authorities, I accept the submissions of counsel for the first defendant. Find that Parliament could not have intended to establish an independent body removed from the police force and subject to the control of no one, but still have the Commissioner and investigative staff of Indicom having to rely on the police and or DPP to initiate arrests of or to charge members of the police force. Parliament cannot be taken to have legislated an absurdity. I therefore find, as submitted by counsel for the first defendant, that the Commissioner and the investigative staff of Indicom have the powers of arrest both under common law. Further, I hold that they also have the power, pursuant to common law, to initiate prosecutions. So, my Lord, that's the counter, as it were, to the argument that Justice of Appeal Phillips, adopted by my learned friend, is emphasising, well, there's nothing expressly there, there's a power to investigate. They're saying there is a common law power, it's not expressly removed, and it must be implied into the Act or held to be still there, or it would result in absurdity if there had to be, as it were, the approval of the DPP.
Well, without putting it unduly pejoratively, your argument runs, does it not? The Commission has given these extensive powers. They were conceived to be necessary because of well-established deficiencies in the investigation of this type of crime. It would be anomalous, to put it at its lowest, if all these investigative powers could be set at naught because the DPP was not as assiduous as it should have been in the prosecution of offences, or because of the way in which prosecutions are conducted in Jamaica, and because of the diffusion of responsibilities among these various clerks and parishes, that all this effort could be frustrated.
My Lord, yes, and we say that there is authority to support the peculiarly advanced point, as it were, that body which has acquired the specialist knowledge and has the specialist duty in the area, the specialist duty being to examine and expose police misconduct and protect the right to life, though they acquire all that specialist information, though they have all this specialist powers, that they then have to hand it over either to the DPP or to the police. Because in effect, the DPP doesn't take personal responsibility for everything. And we know that, regrettably, the DPP was criticised by the Inter-American Commission in the, now I'm going to forget the name of that, it's the Gale case, yes. My Lords, just then, again, it may be sufficient that I just highlight the points, but if I take you to part 4 at page 5, we say there are a number of pointers within the statute itself that support the appellant's basic submission, namely that the statute should be interpreted so as to recognise that Indicom retains and possesses the basic power at common law for a statutory authority to prosecute so as to ensure the fulfilment of its statutory objectives.
Just before you go there, you always speak here of power. Are you really saying that it's one of the functions of Indicom to prosecute? Because if it isn't a function and is only a power, it might meet with the objection that you can only exercise a power.
Well, my Lord, can I put it this way? I would say it's one of their functions to ensure that in an appropriate case there is a prosecution. But it may be that they don't conduct the prosecution themselves in certain cases if they're satisfied that another authority will do so. And that may depend on the nature of the case, the nature of the evidence, the sensitivities of the case. Because I do accept, my Lord Kerr put to my learned friend, that there's a concurrent jurisdiction. There is, that the DPP doesn't lose the power.
He can still take over the Indicom prosecution.
Yeah, exactly. So I accept he has a concurrent power, but my lords, can I just show you those two passages? Because we say that power is particularly recognised in cases where the authority is peculiarly advantaged to prosecute the particular matter before the court, as recognised in the cases of Hunt and Securiplan, which it says analysed below. They are analysed. If I can just give you the reference, we've analysed them at part 6 from page 9 of this note onwards. But the bit about the bit in Hunt that I could particularly take the court to is volume 2, tab 32. So volume 2, tab 32, and it's the actual passage is at page 1299. So volume 2 tab, this is the Inland Revenue Commissioners, and can I just, so if I take the court to paragraph 20, can I just summarise very briefly, although I'm sure the court is aware. It's the case in, it's 1299, paragraph 20. The question was, could the Inland Revenue Commissioners prosecute, and could they prosecute without the DPP's permission, but certainly could they prosecute at all was one of the issues. And at paragraph 20 on page 1299, I'm therefore far from satisfied that the passages in Blackstone support Mr. Rhodes's argument. The procedure involving information discharge was abolished in that. If Mr. Rhodes was right, that would be surprising, because clearly there is a category of criminal behaviour in respect of which the Inland Revenue Commissioners would be in a peculiarly advantageous position to prosecute. To confine the Revenue's ability to bring a prosecution to situations where the Attorney General consents would be out of accord with the general position. Great importance has always been attached to the ability of an ordinary member of the public to prosecute in respect of breaches of the criminal law. If an ordinary member of the public can bring proceedings for breaches of the criminal law, it would be surprising if the Inland Revenue were not in a similar position. And then it deals with the Inland Revenue Commissioners. It would also apply to the Customs and Excise. Now, there's just two passages which I would draw to the court's attention. The first is at paragraph 28, page 1301 of the electronic bundle, at least in my version. I think, is it 1302, is it, in the court's? I don't know why we're a page adrift, but so +1 to anything I say, please. Paragraph 28. The third case, RVW, is, however, much more important. It did not directly involve the issue which is before this court. It is accepted by Mr. Rook that what was said by Lord Justice Rose was obiter. However, it is highly apposite, and I would endorse what Lord Justice Rose said. Indeed, in my judgment, it could not be better expressed. In dealing with the basis of the power of the Inland Revenue Commissioners to prosecute, Lord Justice Rose said at page 555, the Revenue on behalf of the Crown have no express statutory power to prosecute, but have such a power at common law in aid of their overall function. So it's a broad description, overall functions, which are to collect taxes, as it were. And then you see the Revenue having a policy of selective prosecution, and then it goes on there. And then, just remind me, and then over the page after that quotation, Lord Wolfe adopts the further formulation of Lord Justice Rose in RVW, paragraph 29. At the end of his judgment, Lord Justice Rose added, it is clear on principle and authority that the Revenue's common law power to prosecute is ancillary to, supportive of, and I accept, and limited by, their duty to collect taxes. So it's one looks at the overall function.
That's not a problem with the Revenue, whose job is to get the tax in. One can quite understand that if only pour en courage les autres, they should have how far it takes you in relation to the functions of...
Well, my lord, can I just tell you what assistance I said? Firstly, it's an unincorporated body. So that, we say, gives the lie to this idea that you've got to be you've got to be a person, a natural person or a limited company. Secondly, we say, we pronate the language of overall function. And the overall function, as I've sought to characterise it, is to investigate and deal with, or to investigate and confront, do something about police brutality and particularly police killings which infringe the right to life. So that's the language of the overall function. And the third point is that it's talking about a common law power of public officials. So that's the common law power which we say is preserved by Section 34 in the ICIA. So, my lords, I know in the end the court will be left with this dilemma. Is the full court right in its absurdity point, or is the rather arid and technical approach of the Court of Appeal to be preferred? But my lord, that's what it amounts to.
At least you can call it chancery.
My lord, I wouldn't dream of chancery. It's all about equity and justice. But
I suppose you would say, Mr. Fitzgerald, that while it's not an immediately obvious analogy, as my lord puts it, the purpose of the Revenue Commissioners is to make sure that income tax is paid. And the purpose of Indicom is to make sure that these alleged crimes are properly investigated and subject to...
I would say brought to book in
Yeah,
I mean, that it does extend to that. And that's where I respectfully submit that the full court were nearer to the reality of what this is, why this legislation was brought in and what its purpose was, than the rather remote statutory interpretation approach that was adopted by the Justice of Appeal. And my lords, Securiplan uses again the language of peculiar advantage, and that's at volume 3, tab 51. And so, my lords, volume 3, tab 51, and that's 1868. And so, just going to Securiplan, if the court sees at page 1871, this is whether the security industry authority, I think it must have supervision of the security industry generally. Does it have the power to prosecute? Is the heading at paragraph 10 on page 1872. It will be in my lord's.
There is a general power under section 1.3 from the look of it. I'm looking at paragraph 7 of the judgment of Lord Justice.
Yes, general power, yes, may do anything that it considers calculated fast. Well, my lord, we would say that's just declaratory of the common law. That's no different than the common law power that was identified in the Hunt case, the Inland Revenue case. So that, as it were, even if you didn't have a section 1.3, it would be there because it's a common law principle. And then, my lords, if we go over from there, but can I just really draw attention to where one sees paragraph 12 at F. In my judgment, that function is plainly facilitated by the enforcement of the sanctions prescribed by the Act, to the extent that it is an offence to engage in licensable conduct, except under and in accordance with licence. The functions relating to licensing are facilitated by resort to the threat and reality of prosecutions. And then at paragraph 14, I am wholly unpersuaded by a submission that the Act, whilst prescribing regulatory offences, by implication requires the SIA, as the body with knowledge of non-compliance, to outsource the prosecution function to an overstretched police force and Crown Prosecution Service. The SIA is in a peculiarly advantageous position to prosecute, to borrow the words of Lord Wolfe in Hunt, where he was considering the position of the IRC, albeit outside the ambit of a statute and admittedly not a corporate body. So we do respectfully submit that that test, are they by reason of the carrying out of their broad functions placed in a peculiarly advantageous position to prosecute? And clearly that test is what is decisive at paragraph 14 there, and we would submit should be decisive in this case for the reasons really which we've sought to identify.
So in Securiplan, is it a common law power or is it a power by implication under the statute?
Well, it's adopting Hunt, so it cites the Hunt test at paragraph 14.
So again, it's common law.
Common law power, yes.
Well, it might be both.
Yes.
But it might be. That's right.
Yes. Well, you mean the section 1.3 as well, but
Yes.
yes. Well, I accept.
Lord Kitchen pointed out.
Yes, my lord. Yes. Well, what I would submit is that again, the underlying reasoning would apply even if you didn't have a section 1.3. There is a passage. It's right that at paragraph 18, where Mr. Perry for the authority had run the absurdity point, if I can put it that way, and the court, as it were, says, well, we needn't pronounce on that because we're satisfied that it's within the terms of the functions. But one sees at 18 at G to H, Mr. Perry submits that the fact that a private individual, including an employee of the SIA, could bring a private prosecution in relation to these offences demonstrates the absurdity of construing Section 1 in such a way as to deny the competence of the SIA to prosecute. Whilst I see the rhetorical force of this point, in the end I prefer to express my conclusions on this first issue by reference to what I find to be the clear meaning of Section 1, considered in its context, and by reference to the purpose of the Act.
So that would suggest it was by implication under the Act.
My lord, I accept that, but if section...
Point in your favour.
Oh, thank you, my lord. It's always difficult not to be unduly suspicious when I'm not normally representing a responsible authority like me. But my lord, I do say that it comes from the terms of the Act and from the common law as preserved in section 34. My lords, that's really so the pointers are really in the text itself, but just if I can run through them, there's a 4.2, my learned friends really dealt with the emphasis on the independence of the authority in the exercise of its powers shall not be subject to direction or control of any other person or authority. Moreover, those words in themselves indicate is itself a person or authority, as my learned friends said. So it's certainly an authority, and that will do for the purposes of this submission. Secondly, there is the fact that the Commission is entrusted under Section 22.1 with primary responsibility for the preservation of a scene, and as my learned friend Mr. Williams pointed out, Section 4.2d is to like effect. It's entirely consistent with the effective exercise of this continuing power that the Commission should, where appropriate, take charge of the prosecution, where the preservation of the scene of an incident may be a crucial and indispensable precondition for successful prosecution. It is peculiarly advantageous, if anyone puts in inverted commas, to do so. Thirdly, there's the provision of Section 21, which my learned friend Mr. Small is going to briefly summarise the position on, but just anticipate it, which properly interpreted, we say, confers a power to arrest or in discharge of the function of investigation and, where necessary, the overall function of initiating criminal proceedings by arrest and charge. There is no realistic basis on which that power of arrest can be confined to the promotion of a purely investigative role. That is particularly so given that an investigation may continue after arrest and even after charge. We submit that the expression for the purposes of giving effect to sections 4, 3 and 13 and 14 does not limit the powers, authorities and privileges of the constable that are conferred on the Commissioner and his investigative staff by section 20 solely to the power to arrest where there is interference in the investigation. As I understand it, it's accepted that when it comes to those offences which are intimately connected with obstruction of the investigation, which are provided for in section 33, there is no dispute that that one can prosecute in support of that. But the dispute is as to whether, when what is uncovered is an underlying murder, one can prosecute in relation to that, and one has the powers of the police in relation to that. The powers, privileges and authorities of the constable obviously mean you can arrest, and as I think my learned friend Mr. Williams pointed out this morning, you may need to arrest in order to have an identification parade, and that may be essential. But we say that you can also have the powers, privileges and authorities of the constable under section 21 in relation to prosecution. In fact, I think that there's only one special privilege, which is that you don't have to pay stamp duty on an information. But so it's a pretty limited one. But that would also apply.
Fitzgerald, forgive me for interrupting, but you said that there's no dispute that they can prosecute under section 33. That's not my understanding. I understood there was an issue in relation to that.
Well, my lord, can I just put it this way? There is clearly a distinction.
I can see a distinction, but I think there's an issue between the parties as to whether section 33...
Sorry, my
Perhaps I should clarify. No, there isn't an issue. We do accept you can prosecute, Indicom can prosecute for an offence under section 33.
Right.
That's what the majority said in the Diah case.
Well, it's really not clear what the majority says in the Diah case, but for our part, we accept that.
You'll have a chance to explain the opacity of it.
Well, I'm very grateful to my learned friend, but that was what we understood. So section 33 is where there's an offence that actually interferes with the investigation itself, such as Diah is alleged to have done, and it's not disputed that would come within the test of a necessary power of prosecution in furtherance of one's public duty. Because if somebody runs off with the guns when you're trying to box them and test them, they clearly are interfering with one of your core enumerated functions. And so that would come bang within the Hunt-Rollins FSA, the secure plan test.
Well, that really focuses the question very much on what are the functions.
Right. Well,
and do you have an expanded view of the functions, as you would say, or do you have a very restricted view of the functions, as your opponent?
Yes, and my lords, the reasons for an expanded one are the absurdity argument, firstly, at the full court, that this is a public authority, obviously bound to give effect to the constitutional right to life, and the international should be interpreted to give effect to the international human rights law right to life, which involves both investigating fully and prosecuting. That's the second. And thirdly, we say there is a helpful common law principle, the peculiarly advantaged test, and if one asks oneself, are they peculiarly advantaged, given the very grave life and death matters that may hinge on this, including, as I said, the protection until they give evidence of someone who may feel their life is at risk if the police find out their identity, that there are very good reasons why they should be peculiarly advantaged, treated as peculiarly advantaged to carry out that prosecution.
So how far section 20 helps you? If the contemplation of the draftsman, and therefore Parliament, was that the function of indictment extended to prosecution,
yes.
Why do they confine having the powers of a constable, which are obviously very useful if you want to prosecute somebody because you can arrest him, just to giving effect to sections 4, 13 and 14, which are quite narrowly focused on investigation.
Well, my lord, I think there, I know Richard Small may follow on this, but we say you have to give a broad and purposive to the words giving effect. And really that, I'm afraid it comes down in the end to the point that there's no point having the investigation if it doesn't to prosecute. I mean, in the end, that is the point. But what we say is that this may be an extended, for the purpose of giving effect to, it's almost the way you say it.
In any event, you don't have to be a constable at common law to prosecute.
No. Well, so Section 21 is useful when one's determining whether one has a power to arrest. It's important for that, but it's not dispositive of the question of whether there's a power to prosecute. And my lords, when one looks to Section 34, that again, although not dispositive, nothing in this act should be construed as limiting or affecting any remedy or right of appeal, objection or procedure given to any person by any other provision of law. That must, the word law obviously includes the common law, and the common law right to prosecute of a public officer, we would say, is covered by that. Quite apart from the fact that I think, again, this is the majority in the Court of Appeal recognise that just as an individual who discovers evidence of murder could prosecute, so in their individual capacity, just as ordinary citizens, Indicom staff could, but that's not, if I can put it, that's not the main burden of the submission I'm making to your lordship.
Right, where are we in your speaking note?
My lord, we're making very good progress. We've got to page 7, I think, so after 6, or even we say...
4.6, I think you are.
Yeah, I'm right. More even if Section 34 were not there, the officers in Indicom would possess the common law right of the officers of a public authority to prosecute in aid of their overall statutory functions. Finally, there is nothing in the statute to suggest that Parliament intended to impose any restriction on Indicom's power to prosecute for offences which their investigations revealed, and in respect of which they retain control over the evidence. On the contrary, Parliament made Indicom peculiarly advantaged to perform that, and that's the test. The counter-arguments, I think I've really summarised my position, and we've set them out in the reply, but could I just, if I can just give your lordships the key to our points. If one takes the statute itself, the Indicom statute, and goes through the various points made by my learned friend, and indeed by the Court of Appeal, one has it at tab, tab 8, and if one goes first to section 10, yes, the fact that there is, so 5.2, the fact that there are repeated references to the duty to investigate in sections 4, 13 and 14 doesn't mean the power to charge and prosecute as a result of those is excluded, given the general common law principle cited above. Moreover, it was expressly recognised in Rollins that a statute very often does not provide a comprehensive code setting out the powers to prosecute that are conferred. My lords, I don't think I need to, you've got it, the reference there, but I'll take you very shortly to Rollins later. And in the Broadmoor case, it was recognised the power of a public body to bring proceedings is usually a matter of implication. If we look at the various, these are the submissions made by the respondent building on the reasoning of Justice of Appeal Phillips. Firstly, they invite attention to section 10(3)(c). On receipt of a complaint, the Director of Complaints, so who is one of the officials of Indicom, shall record it in the prescribed form, cause an investigation. If, in the opinion of the Commission, the complainant will forward a copy of the complaint to the DPP forthwith. What we simply say is that is as consistent with there being a concurrent DPP power as with there being an exclusive DPP power to prosecute. It doesn't really settle the issue. And indeed, on our submission, of course, the DPP needs to be notified and consulted in relation to some issues. But in the end, the Indicom has its own right and indeed its own duty in certain circumstances to prosecute. Then the next thing relied on in the interpretation is section 16.1, the duty to consult before determining to use mediation. I suppose this would be where there's a relatively minor police infraction and that there's a determination to deal with it by way of mediation. That there should be consultation with the DPP. Again, equally consistent with the fact that the DPP does have concurrent jurisdiction, as with the DPP having exclusive jurisdiction. If one goes on to 1710D, this is the point about Commission shall furnish a copy of the report of the Commission to, and then there's a whole series of listed individuals. D, the Director of Public Prosecutions. This is the final report. Because, and we've set this out at 5.3, DPP features as one of the 8 mandatory recipients of such a report. This is in paragraphs A to H. So that can't possibly justify the inference that it's only for the DPP to prosecute. Section 23 is also referred to and relied on, and that's at page 931, maybe 932 in my Lord's version. Where a report of the Commission under this Act contains recommendations for action to be carried out by the relevant force or the relevant public body, these should be complied with in the manner and with the time specified. Yes, I mean that, I would say, is more apt to describe the situation where they give a general recommendation for some reform of procedures or protocols than a particular prosecution. But where, and then subparagraph 3, where the relevant force of the relevant public but does not comply with the recommendations, Commission shall, after being made aware of the non-compliance, cause a report thereof to be laid on the table of each House of Parliament. Lord, I think it's at least, one sees at 2, where the recommendations relate to disciplinary proceedings or the production of documents or any other matters, the responsible head of the response decides not to comply, he shall give reasons for the decision. So there's nothing expressly about prosecution there, but my lords, I can't submit that it's definitely excluded, but it seems more apt to refer to more general recommendations rather than specific ones. And then section 25 is relied on also. An investigator shall, on a request by the DPP in relation to a prosecution arising out of an incident, attend court and provide such other support. Well, again, if the DPP has concurrent power and the person has interviewed a witness or found a piece of evidence, it makes sense that they should cooperate. But it doesn't mean that there's an exclusive jurisdiction vested in the DPP. And then, so we say that none of those points justify the conclusion which my learned friend invites, that Indicom's sole object and purpose is to investigate, and that any offence disclosed as a result of the investigation fall to be prosecuted by the DPP, whether on the recommendation of Indicom or otherwise. And then section 28 is, as it were, doesn't feature in the Court of Appeal judgment. We say because it's not a very good point, but my learned friend says it's key, and the first attaches very considerable significance to the provisions of section 28. This is dealt with in the appellant's reply at paragraphs 8 to 10. What we respectfully submit is that section 28 itself constitutes no bar to the appellant's proposition that Indicom has a power to prosecute the police for the misconduct that Indicom's investigations reveal. In particular, section 28(1)(a) implicitly recognises that the Commissioner and his officers can disclose otherwise confidential matters in order to prosecute for offences under section 33(1), and this appears to be conceded or asserted by the first respondent. It may be. So if one sees 28(1)(a), the respondent says, well, it's an expressio unius exclusio alterius argument, really. Commissioner and every person concerned with the administration of this Act shall regard as secret and confidential documents, information and things disclosed to them in the execution of any of the provisions of this Act, except that no disclosure made by the Commissioner or any such person in proceedings for an offence under section 33 of this Act or under the Perjury Act by virtue of shall be deemed inconsistent with any duty imposed by this section is the words from B which apply. So it's accepted that they can prosecute for an offence under section 33 themselves, but it's asserted that they can go no further. But if we look at B, which the Commissioner or any such person thinks necessary to make in the discharge of their function, so that could include a prosecution that's not under section 33, but then there's a further limitation, and which would not prejudice security, defence or international relations of Jamaica. So there's that B has some purpose because there's an additional precondition that it has to be satisfied there of not prejudice the security, defence or international relations. Now, if it's just some I'm not going to give you the guns offence, one sees why one would not have to write that in. But if it's an offence involving murder, which may be in a sensitive operation, one sees why it would have to be written in. And so we say it's not inconsistent with the Commissioner or an officer of the Commission prosecuting for the latter type of very serious offence. And then if we look at subsection 2, this is really a protection, an immunity from being compelled to give evidence. Neither the Commissioner nor any of the persons aforesaid shall be called upon to give evidence in respect of or produce any such document, information or things in any proceedings other than proceedings mentioned. Well, what we submit, it merely limits the power to compel testimony from the Commission and others other than proceedings mentioned in subsection 1 or section 25. That doesn't mean the Commissioner or one of his officers cannot voluntarily give evidence in support of a prosecution. They're not compelled. And any refusal to disclose relevant evidence would in any event be subject to an abuse application in the court. You can't go any further, as it were. That's like the situations where the prosecutor says, I'm not going to give you the evidence because it's so sensitive, and the court says, well, in that case, I'm going to stay the proceedings as an abuse. I mean, I suppose it would also be reviewable in public law by judicial review, but we say none of those provisions are inconsistent with the power that we respectfully submit is there and remains there, the common law power of a public officer to prosecute in support of their functions, ancillary to their functions. And so, my lords, that's really the way we put those submissions. The case law, to some extent, I've anticipated all that, but can I just, for the sake of completeness, go through those? Hunt, that case recognised the right of the Inland Revenue Commissioners, an unincorporated body, to prosecute. It recognised that the Revenue Commissioners had a power to prosecute at common law in aid of their overall functions, and it also referred to the Revenue's common law powers to prosecute as ancillary to, supportive of, and limited by their duty to collect taxes. We say by parity of reasoning, we submit that it's part of the overall function of Indicom, read in the light of the state's constitutional obligation to respect the right to life, to ensure an effective investigation and, where appropriate, a prosecution. And we rely on the passages that I think I've now shown you, paragraphs 20, 28 and 29 of Hunt in particular.
May I just, before you go on to Rollins, can I just ask one question? The common law power of the citizen to prosecute, is that subject to any restriction about the citizen having a particular interest in the subject matter, or is it simply that the citizen, he or she, has knowledge of the commission of a criminal offence?
The latter.
Yes, because that might make more sense of the peculiarly advantaged test,
Yes.
if that is the case, because otherwise it's quite difficult to fit the peculiarly advantaged test into the formula that is assisting a function.
Well, it may have been developed in the context of our, the UK position, where the DPP, under the Prosecution of Offences Act, has a more expansive power, as established by the Goodger case, which I know my Lord will recall, where the question was, not just could the DPP take over, but what sort of test should the DPP apply? And there was an attempt, there was a ruling that the DPP's test of prima facie case in better than even's chance of success and public interest should be applied. Now that wouldn't be the case in Jamaica. Goodger would not apply in Jamaica. You could not impose the DPP's or the UK DPP's power test on the ordinary citizen in Jamaica. So the Prosecution of Offences Act, by giving more extensive powers to the DPP here, may make a difference. But my Lord.
Well, is that because there is no equivalent to the public interest test in Jamaica?
Well, I think the DPP may. I think, after all, the test of is there a better than even's chance of success is a creature of a policy introduced in England by the DPP, which is analysed in the Goodger case. There's no evidence that such a test is applied in Jamaica. As your lordships know, it was a very close 3-2 decision in Goodger. It is quite controversial whether you have to have more than the prima facie case. Because the DPP had introduced the test, we'll stop prosecutions where there's less than a better than even's chance of success instituted by private people in the UK, and that was upheld by 3-2 to be lawful. It may be the situation is not entirely on all fours. My lords, I hope that's, is that vaguely comprehensible, the difference between the, so that...
It's entirely comprehensible.
Thank you. I mean, it's just that, so in the UK, the DPP's introduced a test. I will not prosecute unless there's a better than even's chance of success. If there's a private prosecution going on where he thinks that there is not a better than even's chance of success, he has arrogated to himself the power to intervene and stop it. That would not necessarily be the case in Jamaica. Although the DPP has the power to intervene and stop a prosecution, there isn't so far as I know, there isn't an established better than even's chance of success, and it's not universally applied. So, my lords, that may be a distinction, but in answer to my Lord Hodges' question, that's to say, as I understand what my Lord was putting, why the peculiar advantage test, it may be because where the common law power is that of a public body, you have to find some reason in that public body's functions why it's peculiarly advantaged. We're content to embrace that test, and we have in our cases. But my lords, and it may also be, as it were, before implying into the statute that general common law power, you have to be satisfied that the body that's the authority that's exercising the power is peculiarly advantaged. But we say that we definitely satisfy that test for all the reasons I've sought to identify. My Lords, if one looks at Rollins, that's at Core Volume 3, tab 50, that involved the SFA, and the question was whether the SFA had the general right to prosecute, provided it fell within the scope of its powers. We've analysed that in the reply at paragraph 16 to 17, but can I... hang on. Tab 50, in the EB, it's 1856, I think, my Lords. Yes, sorry. Tell me at the end. At paragraphs 8 to 11, this is in relation to the Financial Services Authority having a general right to prosecute, provided it fell within the scope of its powers. There was a history of the FSA being able to bring a prosecution. So the general position, therefore, is the FSA has always been able to bring any prosecution subject to statutory restrictions and conditions, provided it's permitted to do so by its memorandum and articles of association. Most statutes which create offences do not specify who may prosecute or on what conditions. Typically, they simply state that a person who is guilty of the offence in question shall be liable to a specified maximum penalty, it being assumed that anybody may bring the prosecution. Examples of this technique of statutory drafting are to be found in the provisions of POCA, a person who commits an offence if he conceals property, etc. Section 3281 provides a person who commits an offence, a person guilty of an offence is liable to the maximum penalties. It follows that before the enactment of FSMA, the FSA could have prosecuted the appellant for offences, contrary to sections 327 and 328 of POCA, if POCA had been in force at the time. That's just by reference to the fact that it's within their area of competence. And then paragraph 14, the general position before the enactment of FSMA was that the FSA had the power of a private individual to prosecute, provided that this fell within the scope of its objects and prosecution was not precluded or restricted by the terms of the relevant statute. It's against that background the true construction of FSMA falls to be considered. And then they go into consideration quite technical of the various sections, but at 13 to 14, so that's 13 to 14. Then if one goes on, they apply the test of, well, if we apply the test of provided it's within the scope of its objects, we'd say Indicom, it's clearly within the scope of its objects broadly interpreted, and it's not precluded by any express provisions. Then at paragraph 17 to 19, one sees this is further developed, and legitimate to ask at 17 why Parliament should have intended to deprive the FSA, but no one else, of the power it previously enjoyed to bring prosecutions for offences. So that's the argument about, and then it says no mischief has been identified which required such action. And then at paragraph 18, one sees the thought saying at D, 18D, it also means that if the evidence given at trial does not support a count on the indictment which is being prosecuted by FSA, but it does support a different offence, which ex hypothesi the FSA cannot prosecute, an application for leave to amend would be required. And then it says, this is really the argument from implied parliamentary intent at 19. In these circumstances, it is unlikely that Parliament would have intended to restrict the power of the FSA, the prosecution of the offences mentioned in sections 401 and 402. Then there's the reference about technique usually used, employed by the legislature to indicate intention to limit the number of persons who may prosecute, is that a particular may only be prosecuted by a specified person. So we don't have that, though, although there is that technique available, it wasn't employed in this statute to exclude prosecution for offences other than Section 33, which it's conceded there is an implied common law power to prosecute. And then if one goes on to paragraph, yes, it's striking that it was not employed in Section 402(1), that's at paragraph 20. Other forms of words are used but to the same effect. And then it describes, and then at the end of that paragraph, there is no such provision in FSMA excluding the power of FSA to prosecute offences which are not mentioned. So what we've got to now is a position where it's conceded that there is, though it's not spelt out anywhere in the statute, a common law power to prosecute vested in Indicom to prosecute Section 33 offences.
Common law power?
Yes, common law power, yes, because it's a common law power of the officer of a public body to prosecute for offences where it's necessary to give effect to their functions. And that's how it's described by Lord Justice Rose in RVW, adopted by Lord Wolfe in Hunt. And then one sees that, and one, so, my lords, what we submit is, once it's conceded that there are powers to prosecute which are there for Indicom in respect of an interference with their investigation, Indicom clearly has the power to prosecute. It's not spelt out, but it's there. So one can't say they've got no powers to prosecute. They clearly do, and my learned friend concedes that. Then the question is that power to prosecute confined to Section 33, or does it extend to an offence which is revealed in the course of their investigations, which may be a far more serious offence, such as murder? And we say that it would be very strange if, though they have a power to prosecute for Section 33 offences, the far more serious offences, which they were specially introduced to investigate and given exclusive powers to retain the evidence in respect of, they don't have the power to prosecute. And that's really the absurdity argument of the full court, with the additional point that it would be strange if the position were different for Section 33 and for some underlying crime of far greater gravity revealed by their investigations, because that's where they are peculiarly advantaged to effectively prosecute. That's a submission we make in relation on the Rollins case. Securiplan is the next and last of this series of cases. We've analysed it in the reply at paragraph 20, but we respectfully refer the court to, so that's tab 51, paragraph 10, where it says, it is of course correct that a statutory corporation only has competence to act to the extent that it is empowered by statute. It's also obvious the functions the SIA is prescribed do not include any express reference to prosecution. My lords, we'd say that there's some limit to it's empowered by statute, but it doesn't have to be empowered expressly by statute. Or Hunt would be wrongly decided, and Rollins would be wrongly decided. But there is later on the reference to paragraph 12, where the court adopted a broad approach to the identification of the purpose of the Act and the functions of the SIA. So one sees at paragraph 12 that they're applying the test, does it facilitate their functions? And at paragraph 12F, in my judgment, that function is plainly facilitated by the enforcement of the sanctions prescribed by the Act, to the extent that it is an offence to engage in licensable conduct, except under and in accordance with a licence. the, quote, functions relating to licensing are facilitated by resort to the threat and the reality of prosecution. So again, it's not expressly there, but it's necessary to facilitate their functions of licensing. And then one sees at 14, this is the passage, I think I did show the court already.
This is the outsourcing point.
Yes, the outsourcing one, yes. Yes. So, and the adoption of the peculiarly well-placed test, I think, is there too. And so, yes, so, my lords, those are the major authorities. I've referred you to the Broadmoor case, which is really more about a statutory injunction. That was where the patient wanted to publish a book about his crimes and experiences, and the Broadmoor authority intervened to seek an injunction. The question was, did they have that power? And the answer was yes, if it broadly conformed with their duty to look after the patient, as it were, or look after and control the patient. So again, a broad approach was adopted. My lords, at paragraph 7, we make the point that there's no need for the DPPs.
Just before you do, can I just take you back to section 28?
Yes.
Electronic 933.
Yes.
I don't think that, correct me if I'm wrong, your submission suggests that proceedings mentioned in subsection 1 or section 20 includes, for example, proceedings, a criminal complaint of murder arising
No,
investigation.
I accept that.
Because although they might be, under your submission, proceedings in discharge of their functions under B, which is part of subsection 1, they're not mentioned as such. And if that's right, why should Parliament be thought to have required, to have removed any of the secrecy restraints on disclosure in relation to the lesser offences under section 33, but to have given, if you like, a power to make disclosure in relation to murdered proceedings, but no obligation to make disclosure at all? Why should they be, if Parliament is thinking, actually, we positively do contemplate this organisation as having a serious criminal prosecution function outside section 33, should it have conferred that curious kind of immunity in relation to such proceedings in subsection 2?
Well, my lord, the only response I can give to that is, firstly, this is about, as I said, a power to compel to give evidence.
Yes.
Be called upon by subpoena. And
well, it might be a power in the trial court to require disclosure to be made by the prosecution.
yes, and my lord, the reason may be the sensitivity of the materials that they may have. They can't be compelled, but my lord, there would be other.
Well, I've got your abuse. I understand your abuse point.
You just say either you give it to us voluntarily, or we'll stay the proceedings, or which happens. I
understand that entirely. Now, I'm just asking the narrow question: why Parliament should have, if proceedings in the third line before the other than,
yes,
did include in Parliament's mind actually serious prosecutions arising out of the investigation of the very things they've been investigating. Why would they have said that?
Well, my lord,
the hint I'm sort of worrying about
yes,
is whether they can't therefore have thought that such proceedings would be part of Indicom's function.
Well, actually, my lord, if one thinks of that, that wouldn't matter whether they were. It's just supposing the DPP is prosecuting.
Yeah.
It might be just as important to have the materials which the Commission has obtained, because they might include. So,
isn't that caught by Section 25? DPP can require it.
An investigator shall, on the request, yes, I see, in relation to prosecution arising, attend court and provide.
I appreciate it might not help a defendant, but certainly the DPP could say, come on, you've got to produce these documents.
I accept that, my lord, yes. Well, my lord, our submission is that there may be reasons why the Commission do not wish to be compelled to give evidence.
I'm thinking more of production of documents.
Yes. So, your lordship's putting to me, if it goes under section 25, then the DPP says, give it to me.
DPP will be under a disclosure obligation.
Under a disclosure obligation.
And the DPP can say to the Commissioner, come on, cough up the documents.
But so if the Commissioner were choosing to prosecute, he could say to the investigator, who was his official, give me the material, and he'd do that in his capacity as Commissioner. He wouldn't be doing it in requiring a court order to compel. He would have control over the material which was part of the Commission's investigation. Exactly.
Grateful I hear my learned friend assenting to that. I know that my learned friend also has dealt with the 28.1 point in his submissions. My lord, I know it sounds like kicking for touch, but it is nearly 4 o'clock. Can I, in response to that one,
No, please
okay, and may I apologise for saying the 28.1 point was so unworthy that it didn't find its way into the Court of Appeal. I accept that it's a point I need to address.
But one would have to be, if you're right about the common law, and you need to abrogate the common law, even if section 28 were inconsistent, or not necessarily inconsistent, but didn't work ideally in the form of the existence of the common law, that doesn't mean that Parliament is abrogating a common law.
Yes, yes. It would be by a very roundabout route if we are to interpret it as excluded by virtue of 28.2.
We can return to this tomorrow.
Yes, yes. Well, my lord, yes. So then there's, well, my lord, on to an easier point. No need for the DPP's approval. That's part 7. My lord, I think that. If one looks at that, there's no warrant, we say, for the supposed requirement the DPP should give consent before either Indicom or an individual official of Indicom initiates a prosecution. That would require an express provision, a C. Rollins, and also Steadroy Benjamin, which my learned friend has taken to, where I think Lord Wilson says it doesn't even deserve serious consideration, this point that the police can't prosecute without the approval of the DPP. So we say the Constitution, we say, makes absolutely clear in section, it is 94, is it 93 or 94? Is it 93 or 94? It is 94, it is 94. That the DPP has no exclusive power to initiate prosecutions. He has only the more. So if we look at the Constitution very briefly, it's at tab 3, I think, of the one sees section 94, page 8, yes, 878, there shall be a Director of Public Prosecutions whose office shall be a public office. A person shall not be qualified to hold or act in the office of DPP unless he is qualified for appointment as Judge of the Supreme Court. The same provision applies to the Commissioner, that one must be qualified for appointment as Judge of the Supreme Court. And then the Director of Public Prosecutions shall have power in any case in which he considers it desirable to institute and undertake criminal proceedings, and then B, to take over and continue any such proceedings instituted by any other person or authority, and to discontinue at any stage before judgment is delivered any such criminal proceedings instituted or undertaken by himself or any other person or authority. And it's in connection with that, similar provisions in the Antiguan Constitution, that Lord Wilson said that it's simply unarguable that you can go from the power to take over something instituted by someone, another person or authority, or the power to discontinue it, to saying they cannot institute without the DPP's approval. So we respectfully submit that on just really fundamental constitutional law principles, it cannot be right to say if there is a power to institute proceedings, that they can only be instituted with the DPP's approval. So that's the complete answer in the case of Diah to the argument that the DPP had to give his approval. We say also in this case, it's the complete answer in the Indicom declarations case to any suggestion that the DPP must give prior approval before the authority in this case institutes prosecution. It's just wholly inconsistent with section 94(3) of the Constitution as interpreted in Stedroy Benjamin and as apparent from the plain words of the Constitution itself. My Lords, I think my learned friend did show you Stedroy Benjamin, but
He did indeed.
yes. So there's nothing in the statute that expressly or implicitly removes or negates the common law power of Indicom as a public authority and its officers to initiate a prosecution in furtherance of its public functions, nor is there anything that subjects the prosecution of the police for misconduct to the approval of consent of the DPP. And my Lords, we've put in a very short further point about the unincorporated body point. I hope...
Do you want to preserve that for tomorrow morning?
Yes, my Lord, yes. But whether there's a short summary there, but I'll show you...
It won't take you more than a few minutes, will it?
My Lord, no. Not with your insistent urging to... no, my Lord, I'm sorry. I'm not meaning to be...
A gentle cajole.
No, my Lord, it won't take long. It's set out there, but we just say that we're just... Lord Wilson in Gujra, Volume 2, Tab 33, talks about the general powers of all the different bodies that can initiate inane prosecutions, which include unincorporated bodies, and Halsbury's laws. I think my learned friend has already taken you to Volume 8, Tab 140, page 3672. So that's all I've got to cover, my Lord, other than maybe to return to section
28.
and adopt my Lord Hodges'
Yes. Well, we'll all think
perhaps
about Lord Hodges' point.
You can think about that and decide whether to adopt it in the morning.
Right, we'll sit again at 10:30 tomorrow. Court's now adjourned.